Welcome back to one more session. Today in this session I am going to explain about quasi-contracts. What are quasi-contracts? Quasi-contracts are the contracts which are not real nature. Not real means generally in general contract means there should be an agreement and it should be legally enforceable. But here in quasi-contracts there is no agreement, but it has legal obligations. Sometimes there are situations when a person is required to fulfill those obligations that neither arise out of any contract nor tort, but somehow resemble with those that have been created by contract. Such relations are known as quasi contracts or contracts implied in law, are legal obligations that arise from circumstances. For example, a doctor provides emergency medical care to an unconscious patient. Or one more example, a minor's parent dies and a guardian provides essential goods and services. The main aim of quasi contracts is to prevent unjust enrichment and ensure fairness in situations where no explicit agreement exists. Chapter 5 of the Indian Contract Act 1872, sections 68 to 72 incorporate such obligations, though the word quasi-contract has not been used in anywhere, which means that nowhere in the Indian Contract Act the term quasi, the Indian Contract Act 1872 does not use the word quasi-contract but provides for the following are 5 types of quasi-contracts obligations from section 68 to 72. They are briefly: supply of necessaries to a person incapable of contracting, reimbursement of money paid by interested person, liability of person enjoying benefit of non-gratuitous act, responsibility for the finder of goods, and the last one, liability of person to whom money is paid or thing delivered by mistake or under coercion. These 5 sections are deals with quasi contracts. Here there is a case law, that is Municipal Corporation of Delhi versus Puranmal. In this case, 1974 case, in this case the Supreme Court held that quasi contract as a valid legal concept in India. In recent years, in 2016, Bharat Sanchar Nigam Limited (BSNL) versus Resilient Technologies Limited. In this case, Supreme Court applied the quasi-contract principle to a dispute over unpaid telecom services. So these are the case laws which are related to the quasi-contracts, and along with the Indian Contract Act, some other statutes or the sections relevant to the quasi-contracts from other statutes are Section 22 of the Specific Relief Act 1963 and Section 21G of the Consumer Protection Act 1986. These are also deals with are relevant to the quasi contracts. Quasi contracts are nothing but certain relations resembling those created by contract, even, but they are not real contracts, even though what are the characteristic feature of a contract has, that quasi contracts also have the similar characteristic features. Thank you.